The Supreme Court first established the political question doctrine in Marbury v. Madison. This doctrine provides that courts shouldn't address disputes that don't concern individual rights, but involve policy choices or value determinations that are constitutionally empowered to another branch of the federal government. Since Marbury, the court has invoked this doctrine many times over, refusing to involve itself in issues such as impeachment, treaties, and gerrymandering. In Colegrove v. Green, the court declined to, quote, enter the political thicket, unquote, of congressional district apportionment. The population in the state of Illinois shifted significantly during the first half of the 20th century. By 1946, the population in some urban areas outnumbered rural areas 9 times over. Despite this urban growth, the state refused to change its congressional voter district boundaries, which had been drawn over 40 years earlier in 1901. As a result, an urban citizen's vote carried less weight than a rural citizen's vote in electing members of the U.S. House of Representatives. Because of this inequality, 3 urban Illinois voters, including Kenneth Colegrove, filed suit in federal district court against Illinois Governor Dwight Green and other state officials. Colegrove asked the court to declare the Illinois reapportionment law unconstitutional, which would effectively enjoin the state from holding an upcoming congressional election. He argued Illinois' refusal to equalize the populations of its congressional election districts violated his and other urban voters' constitutional right to vote for congressmen under Article 1 and their 14th Amendment right to equal protection of the laws. The state moved for dismissal on 2 grounds. First, that the Federal Reapportionment Act of 1929 didn't require states to ensure equal population among voting districts, and second, that congressional district apportionment was a non-justiciable political question. The district court agreed with the state's first argument and dismissed the case. The Supreme Court then granted cert.